Judge, Mr. Fletcher represented to me outside. He misunderstood what you were asking with regard to the pleas of true and not true, and with the court's grace, if he could change his plea of true to not true on the possession of marijuana allegation in the MTRP.
Mr. Smith, any objection to that? We're going to have a hearing on all of it anyway. So that's in cause number 21, 37809. He had pled true to count 4, and you're asking to withdraw that and have pleas of not true to all counts. Is that correct?
Yes, ma'am.
Okay. All right, then I will make that modification, and again, we'll set it for, get an updated pre-sentence report, as well as I will get with you guys about what we're setting it for in the next couple days.
Thank you, Judge.
All right, you're free to go. Now, I went and got, just a new prescription, but. Good morning, are you Jamarian Martin? Speak up, please. And will your client waive the formal reading of the indictment?
No, Your Honor.
Mr. Martin, in cause number 25, DCCR 0196, you're charged with the state jail felony offense of burglary of a building, and that's from October 3rd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Are you pleading guilty freely and voluntarily?
Do you understand what's going on?
I do.
You do? Huh?
I said I do got some.
All right, so are you entering your plea freely and voluntarily? Did anybody make you plead guilty? No? I can't, huh?
I said open freely volunteer.
He said freely and voluntarily.
Okay. Has there been any issues, Mr. Parker?
There hadn't been, Judge. No.
Mr. Martin, if I test you this morning, you can have something in your system?
Not sure.
You're not sure? Have a seat in the jury box. Let's find out. Good morning, sir. You're Liza Riley. And Mr. Riley, in cause number 25, DCCR 0380, you're charged with the third-degree felony offense of deadly conduct discharging a firearm. Are you sick? Are you sick currently? I can't hear you. Are you sick?
No.
Then pull that down so I can see your face. Stand up. So you're charged with the third-degree felony offense of deadly conduct discharging a firearm, and that's from December 21st of 2024. Your indictment alleges that you were previously convicted of possession of a controlled substance, third-degree felony, in 2011. And what that means is if you go to trial in this case and you're found guilty and that prior conviction is true, the range of punishments between 2 years and up to 20 years in prison. Do you understand?
Yes.
Speak up.
Yes, ma'am.
And I have here on...
I know there's a rejection that's been signed in this case. I'm asking we don't set this case for trial yet. There's a witness statement that contradicts a lot of the facts that are alleged. I need to look into that before we set this for trial.
Okay, so why don't I just delete that and let's reset it one more time and for y'all to do that. So Mr. Riley, before I set your case for trial, it sounds like there's some more discovery and evidence that needs to be looked at. So I'm going to do one more reset for everybody to look at all of that. And when we come back, if there's still a rejection and we need to go to trial, then we'll get it set at that point, okay? Stay in touch with Mr. Rojas. He will let you know when you need to come back. You're free to go. Thank you. Good morning. Are you Joan Krause?
Yes, ma'am.
And Ms. Krause, this is your initial appearance in cause number 25, DCCR 0904. You're charged with the third-degree felony offense of driving while intoxicated, third or more, from July 16th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I got a court appointment.
Right. So when you're in custody, we automatically give you a court-appointed lawyer. If you make bond, I expect you to at least try to hire your own lawyer. Are you working?
No, ma'am.
Okay. Why aren't you working?
Retired.
Okay. And so you have a retirement income?
Yes, ma'am.
So what I'm going to do, Ms. Kraus, is reset your case to give you some time to try to hire a lawyer. Okay, you need to, if you get someone hired, bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
Okay.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
I do, ma'am.
And are you, do you have the ignition interlock device on your vehicle?
No, ma'am, I don't have one.
You're not driving. I want to make sure you understand it's a condition of your bond. You cannot drive unless you have that on your, any vehicle. Do you understand?
Yes, ma'am.
Okay, step in front of the clerk. She'll give you your reset notice. Sarah Henderson. Diamond James. Good morning, ma'am. You're Diamond James. And did you get someone hired? Speak up, please.
No, ma'am.
Who'd you talk to?
I spoke with Kyle Walker, he said 7,500, but no payment plans on the down payment.
Okay.
I spoke with, is Jax or Macon,
Mm-hmm.
they said 7,500 as well. I spoke with Franklin and Associates, 10,000, the minimum is 7,500. 500 every 2 weeks, but the way work has been going, the hours have not been 8 hours a day, so.
Right. So thank you for doing what I asked you. I'm going to let you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct. So put whatever your bills are, whatever your income is, and then I'll take a look at it. If you step in front of the clerk, she'll give you that, those instructions.
The nature of this plea originally, Judge, was obviously a little bit low. It was based on some cooperation, non-cooperation, cooperation, non-cooperation, which I believe is still the case. I don't know what
Look this way.
is, I don't
You
know
look
the
this way.
relationship between the two of them. Obviously, I'm concerned for that. It's my understanding through Ms. Lopez that they're continually together and that in addition to Mr. Bell, she is also violating that no contact order by voluntarily engaging.
I think they got children together as well, is that right?
Well, that's
And
why-
they're pregnant now, is that right?
But that's why I made the specific rule that they go through a third party to transfer kids, to see
And
kids.
the problem is that the third party is his mother, which is, I've told him multiple times, cannot be.
Cannot be. Okay.
It's not working.
You are pregnant with this child right now?
Yes, sir.
Okay.
So here's the thing. I can't necessarily order you. You're not here in court on an offense. But he's going to jail today because y'all won't quit doing what I told him not to do. So it's that simple.
Can I say something? Whenever I did call the probation officer, technically he was already staying at the house. We both our managers are in the house. He was already staying at the house. So when I went to the house, I just wanted him to leave because, me and the kids needed somewhere to go. And I called the probation officer on my own, but he was technically staying at the house already. I just wanted him to leave because me and the kids needed somewhere to go. And obviously we all couldn't be there.
Right.
But he haven't.
So did he not leave so that you and the kids could stay there and that's why you called?
Yes, ma'am.
Okay,
But
then
he's
it's,
been staying there.
all right, well, then you know what you have to do. You're the one
I
on,
got out the house and I waited on my ride before my ride came.
Well, if you're staying at the house,
I
and
don't
you're-
stay there anymore. I stay with my this
I'm resetting it for a sentencing hearing. If there's any testimony at that time, you can recall witnesses, and so we'll come back.
Your Honor, I would implore the court to admonish them that contact includes calls from the jail.
It does. Contact, communication. Contact doesn't just mean in person, all right? It means communication. So you can't call her from the jail. You can't talk to her, period.
Man, we have children together. We have 4 kids together. I'm going to have another child for him. How are we supposed to do? How are we supposed to co-parent if we can't talk to each other?
Well, y'all can't co-parent. That's why we're here. Because he assaulted you. He's on probation for felony assault of you. So we're not co-parenting isn't where we're at right now. Right now, we're trying to keep you, that baby, and the rest of your children safe until I know he's following all the rules. He hasn't done the classes that he's supposed to have. He's using drugs. That's not safe for y'all. That's not co-parenting.
Man, I was ready to have another baby.
I'm sorry. There's choices that both of y'all are making, and that's the choice that you're making to still be with somebody that assaulted you. You can go back, go.
Thank you, Judge.
You can go with the bailiff. Good morning, you're Louisa Magruder?
Yes, ma'am.
And Ms. Magruder, Mr. Rojas told me this morning that you have the intention of trying to hire an attorney?
Yes, ma'am.
Okay, so I need you, if your family or you is going to do that, I need that done within the next 30 days.
Yes.
I'm going to reset your case one time. Obviously, I can't have you just sitting in jail while we're not doing anything on your case. And so Mr. Rojas will remain your attorney until or unless you hire someone. If for some reason it doesn't work out that you hire someone before that next court date, then we're going to move forward with Mr. Rojas, okay? Okay, you can go back with the bailiff. All right, again, sir, you are Ray No.
Yes, ma'am.
And Mr. No, in cause number, hold on, let me get it pulled up. Cause number 25 DCCR 0386, you're charged with a second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 0387, you're charged with a state jail felony offense of driving while intoxicated with a child under 15. In the same offense date of December 11th of 2024. And in that case, if you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
I have here on the tablet in each of your cases plea bargain rejections that you've signed with your attorney that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. In the intoxication manslaughter case, that offers for 18 years in prison. And then in the
I think I'm watching it wrong. Should be 2 years. Should be.
2 years state jail?
Yeah.
No, okay,
Yeah.
all right. Okay, if I make that modification?
absolutely,
Thank you.
Judge.
So in the other, well,
And if you can't read my writing, I'm
nope,
happy
that's
to-
okay. I'm obviously don't know how to erase because now I'm just making marks all over this document. I feel like I know how to.
Should do it.
Okay, so, good grief. It is a Monday. All right, so in that state jail felony case, the offer is for 2 years. In the state jail prison, it would run concurrently with the other case. You have every right to reject these offers and have both of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am, I understand.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am, I do.
Okay, we'll get that done. And Mr. Coleman, is there any reason to believe that these offers would change? Is there any evidence that you're waiting on or anything like that?
No, no.
So I do want to make sure you understand that after today, Mr. No, I won't accept this plea agreement. If you change your mind and want to enter a plea of guilty, that would be to something different or open to the court unless there's new evidence that your attorney or the district attorney gets or finds out about between now and then. Make sense?
Yes, ma'am.
Okay, we'll see y'all at trial. We'll get it placed on the trial docket.
Thank you, Your Honor.
Thank you.
Your Honor, may I be excused?
Yes, sir, thank you. Good morning. You're Bernasha Gloston? And were you able to get someone hired?
Yeah.
Were you able to get a lawyer hired?
I talked to 3 lawyers, like you said. I talked to Lori Perezzo, her assistant Catherine. She said 5,000 through 7,000 was their price. I talked to Brittany Holmes, her, like that's the
Mm-hmm.
She said 3,000 to 5,000, and Dustin Garner is the one I'm considering going with. I talked to him through his main cell phone, and he said his prices was $8,500 to $3,500.
Okay. So how long do you think, you have the money to try to get him hired?
Me and him discussed the case already. I talked to my uncle, which is the one who helps me pay.
Mm-hmm.
He said that I can, get to, I can go for him if that's what I want, but the man, everything he says sounds convincing.
Sure. So if I reset your case one more time, you think y'all will be able to get Mr. Galmore hired?
Yes, ma'am. If not, then I'll have to get a court appointment.
Sure, and so, you did everything. If you think you can afford him, I'll give you about 30 days or so to see if y'all can get that worked out. If not, when you come back, remind me of what you've done, and also talk to some others and bring me those names, because there may be some others that, go ahead.
Sometimes they be a little busy, because I called several ones before that,
They are.
Perezzo, she was busy that day, because I think she was in court all day for criminal days.
You just have to keep trying them, but if you get him hired, bring the reset notice to him. If it's not going to work with him, talk to a few others, bring me those names, and then when you come back, we'll talk about a court appointed if that's not going to work out, okay?
Yes.
All right, step in front of the clerk, she'll give you a reset notice.
I'm killing myself. Be like a blind man here shortly.
All right, so you're James Lofton?
Yes, ma'am.
And Mr. Lofton was previously in court. Now, the misdemeanor is something that, remind me, why do I have that on?
He was supposed to have pledged in his misdemeanor several resets
Right.
ago each time prior to coming down here, because our plan is to have him, we had talked about
To extend
ISF,
probation and ISF.
but now it's for safety if the court considers based on this update PSI, but obviously we can't do that until he pleads to the list.
Well, I can do that today, and he can go into custody, and y'all can go take care of it.
That's what I was just gonna.
Because he'll sit in custody until he goes and
Correct.
takes care of that other case, because he won't go. All right. So in cause number 16-24485, first year James Lofton. Mr. Lofton was previously in court, and that is a motion to revoke probation. On probation for the third-degree felony of assault, family violence. It was a 5-year deferred at one point, and then in February of 2020, that probation was revoked and given a 10-year term that was probated for 5 years, so went to a straight probation, placed on high-medium caseload and zero tolerance. I've received the updated pre-sentence report also. Has everyone had an opportunity to review that report?
Yes, ma'am.
I have your own.
Any additions or corrections to that?
No, ma'am, the only thing I would say is since PSI is that we have, this last week, we have gone and taken a drug test of Beaumont Occupational, and my client has, is that, and I have those drug test results at the court would entertain.
That's not going to change
Okay.
what I do. Based on the nature of that examination and the substance abuse evaluation, I'm going to follow those. I appreciate that he stayed clean for some amount of time.
Yes, ma'am.
But if I'm going to follow after what I just said with regard to the nature of where we've gone on this, he looks like there's a new misdemeanor, driving while intoxicated, second, and that was from December of 2023. We're just finally getting here, so I'm going to do what's necessary, I think, if I'm going to leave him on probation to keep everybody safe.
Like I said earlier, Judge, Mr. Barrington and I had previously discussed after we both reviewed the PSI that safety may very well be in the best interest.
That's what it appears from that evaluation, and so I rely on them and their evaluation to say what's best and do it. And they're talking about the not just the regular safe P, but special needs safe P, so that it covers everything from mental health to drug treatment to everything else that would be necessary, hopefully, for Mr. Lofton to finally be able to complete this probation. In addition, I will have to, and not just have to, but I will need to extend and plan on extending that probation period as well, because it's up either already or this year, and it's only pending because of the motion. Is that right?
Yes.
Okay. All right. So anything else with regard to that updated report or with me going forward with sentencing?
No, ma'am, other than the fact that he is working, I have his employer here, if you'd like to hear from them. We would ask that the recommendation initially was ISF, and we would ask the court to consider ISF and sentencing instead because he has been working with stable employment with his employer for more than a year and a half now, has had stable housing as far as that goes, and so we feel like that him going to safety would cause, financially devastating for him. And so we would ask that he be allowed to go to ISF and then have more strict monitoring on weekly reporting and weekly drug tests with zero reporting.
Ms. Malfino?
I defer to the court's discretion there, but just my review of the PSI, I think safety is probably helping for
And so with regard to Ms. Jefferson, you initially also agreed that ISF with being on the high-risk caseload after would be appropriate. Is that your, what are your thoughts?
Yes, that was my initial recommendation. But I also included that I don't know much about his case because he had absconded for, I believe, over 2 years.
Yeah. And it looks like there was tested positive for methamphetamine August 14th, last month, denied using it, but stated he had used a month ago, but tested positive for it. So I'm trying to see what specifically, why special needs?
I don't believe there was any sort of psychiatric.
I didn't see that either, so I'm not real sure.
That was kind of what, the only question I had about it was.
I don't think we need.
Special needs is generally.
It is, if there's
more
some
of a
type.
psychological type situation.
We don't have that, so
No, we
it's just
don't.
regular. Okay, so here's what I'm going to do. Mr. Lofton, I am going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I am going to continue you on probation. I'm going to extend your probation period for 3 years. I'm going to order as a condition of your probation that you enter and successfully complete the SafeP program, not the special needs, but the regular SafeP program. And that you'll be on the high-medium caseload when you get out. You'll be required to do aftercare. I don't know how to stress strongly enough that this is your last chance. You will not, if you are back in here, I'm going to look at this paper and I'm going to wonder what I did and why. So you will be required to have a drug patch on at all times when you get out. If there's one positive, you're back in here and looking at that 10-year term. You've already agreed to 10 years, no negotiations, no whatever. This is it. You violate, you're getting the 10 years that you agreed to way back when. Do you understand? Yes.
Judge, the only question I have is, I think he was put on probation in 2016, wasn't he? Is that, can we extend for 3 years?
Well, he was put on a deferred in 2016,
Okay.
and then he was revoked and given a straight probation in
Okay.
2020. So actually, I could extend him for 5 more years
Got it.
instead of just 3.
Got it. Fair enough, Your Honor. Thank you.
I'm going to hand you the trial court certification. I need y'all's signature on that, showing that this was an agreement that I followed, and so you've waived your right to appeal. You'll go into custody. Obviously, Mr. Barrington will get it set up as quickly as possible for you to go take care of that other case down the hall in misdemeanor court, because until that's taken care of, you will not be able to go to SafeP. So y'all need to get that taken care of as quickly as you can.
Yes, sir. Yes, sir.
Thank you for being here. Thank y'all.
May we step over here, Your Honor?
Y'all just sign it real quick right here and they'll take them back. Thanks, Mr. Barrington.
Where's the sign on this? Just right here where it says defendant?
Here, I'll give you the, hold up a sec. Here you go. The copy for you and him.
Thank you.
Thank you, sir. Looks like he's got something. Thank you. All right, again, you are David Holland. And Mr. Boudreaux, will your client waive the formal reading of the indictment?
Yes, ma'am.
Hold on, just a moment.
Judge, while you're pulling it up, I'd like to state that I looked up this defendant's jail credit. It looks like he's already got 2 days jail credit to go toward his sentence in this part of his plea. And also, I have no reason, while it's in the sheriff's discretion to grant 2-for-1, I have no reason to doubt that he wouldn't get the 2-for-1 as customary at the jail. But again, it's for the total to the sheriff.
Right, okay. Thank you. Let me get this, so we're going on count one, well,
Lesser
count
included.
one and the lesser included.
Yes, ma'am. The state would abandon the additional counts, all but paragraph 1.
And in that count to the lesser included?
Yes, ma'am.
Thank you. Okay, Mr. Holland, in cause number 21-36992, the state is elected to proceed on count 1 only, and in that count to the lesser included offense of theft from October 6th of 2020. And how do you plead to that charge? Speak up, please. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Boudreaux? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And the agreement is for 30 days in the Jefferson County Jail, and you understand? And you'll get whatever credits you already have, and then what the jail does with regard to 2-for-1 or anything like that is up to them. And are you a U.S. citizen? And you're ready, and and you understand you'll be going into custody today, correct? Okay. State tenders number 1.
Yes, ma'am.
Any objection to state's number 1?
No, ma'am.
It's admitted. Is there any evidence that Mr. Holland is not competent?
Yes, ma'am.
Is there any evidence that he's not competent?
No.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser included offense of a Class A misdemeanor theft, sentence you in accordance with that agreement to 30 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. There you go, and then you can just go back with the bailiff. That's for him. And Mr. Coleman, would you mind helping out with that discovery certificate, the attachment?
I'll read it to each one.
That's for your client. That's his.
Give it to him.
Thank you, Judge.
Thank you, and thank you, Ms. Holmes. Good morning, you're Benita Graham?
Yes, ma'am.
And Ms. Graham, did you get a lawyer hired?
No, ma'am. I did visit three.
Who'd you talk to?
I talked to Kendra, Ms. Holmes, and Attorney Adams. And
Okay,
he did state, Attorney Adams did state if he was elected that he would represent me pro bono.
okay. So, well, what do you mean if he was elected? I don't.
Well, if you assigned him to my case.
Oh, yeah, it doesn't work like that.
Okay.
Okay, so are you working?
No, ma'am.
Okay, why aren't you working?
I'm retired and I only have one source of income, and that's Social Security for my husband's death.
Okay. All right,
And
so,
I do have cancer.
Okay, so what I'm going to do this morning, Ms. Graham, is have you fill out some paperwork. Thank you for doing what I asked you to do, to see if, I'm going to have you fill this paperwork out to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely, don't leave it all blank or put zeros, and then I'll take a look at it when you're finished. If you'll step over in front of the clerk, she'll give you that information.
Actually, about the monitoring situation, if I can be relieved from it.
Let's take care of this first,
Yes,
okay?
Did you need to-
Good morning, Anna.
Okay.
Joan Kraus.
Which is great, because